All right, everybody, welcome back from our nice little break that we had. Okay, we are on page number 9, and we had just started talking about work orders. And well, we actually started talking about your maintenance teams, discussing the how vital they are to the um, compliance health at your property for the work that they do, the order in which they must do it, their interaction with the residents. And I had mentioned about work orders and making sure that your maintenance teams, whether they're whether they're new or whether they've been in the industry for a while, understanding that they know what those written policies are at the community for how businesses should be conducted with regards to adhering to answering work orders. It's important as well. We're at the bottom of page 9 that your maintenance teams know what their role is, and what I mean by that is they are responsible. They have certain responsibilities, such as taking care of the grounds at the property, the common areas, maintaining that curb appeal, answering work orders. They're not responsible for knowing what your availability is of your units. And so that's where, let's say that they're approached by someone while they're out on the grounds, and they approach by a prospect or even a current resident. Maybe a current resident has a family member that's going to be moving into town, and they're looking for a place to live, and they ask the maintenance person about availability. And the maintenance person then they say, well, I was just, you're looking for a 3-bedroom. Well, yeah, we have a 3-bedroom that I know is ready to be leased up. So, maybe you like that one back in building 3. What you do is the maintenance responsibility is to tell that resident they need to speak to someone in the front office, because that's where the core of the responsibility is for notifying residents, applicants, what's available, what are those units that are available. So it's just a matter of making sure that your maintenance staff knows what their role is, because again, they interact more with residents and prospects on a daily basis than sometimes those that are in the front office. So let's look at some more examples. I want you to turn now to page number 10. We're going to look at some other workshops. I said examples of workshops. So what would you do? And this is in conjunction with just discussing the roles of our maintenance teams. A maintenance technician is leaving a unit after repairing an issue. Before she hops on the golf cart to drive to the next unit, a resident from another unit runs up to her and asks, "Can you come to my unit and fix my stove? One of the burners is out, and since you're already here, can you come and fix it?" How should the maintenance technician respond? The maintenance technician should absolutely direct that resident to place a work order by way of whatever the means are at the community, whether it's by way of the resident portal, if they just call the front office and place a work order, or if they stop by the front office and place the work order. What the maintenance technician should not do is say, okay, sure, you're right. Since I'm here, let me just go ahead and come to your unit and fix it. Why? Because you have policies in place for what is priority as far as work orders, and you don't want to show favoritism. You don't want to show discrimination against one resident from the next because you decided, well, you're right, since I'm here, I might as well just go ahead and fix the burner on your stove. We all know, working with residents talk, and they talk a lot. Word travels fast. So it wouldn't be long before that one resident made a comment to another resident and say, well, the maintenance person came right to my unit and fixed it. And they're like, well, wait a minute, they didn't do that for me. It's been 2 days and I'm still waiting on them to come in and respond to a work request I put in 2 days ago. All right. So again, as I mentioned to you, fair housing discrimination is not always intentional. They're just things that, by not following rules and procedures and understanding the fair housing laws, that's how you can find yourself in a fair housing violation. Here's another workshop. It says a maintenance technician has just completed a work order in a 2nd floor unit. As he is leaving, a resident who is moving into the building notices him and asks if he can help move a heavy piece of furniture upstairs to his unit. How should the maintenance technician respond? Well, you've got to be very careful to not do this on the maintenance side. Why? Because first of all, it is not part of your job description to be a furniture mover. That is a liability on behalf of the management company, your employer, if you are moving furniture, helping residents move furniture, and that is not a part of your job. You don't also want to do favors. You may be a strong, strapping person, whether it's male or even female, and you may decide, well, I can do this, it won't take long, but that is a problem. It's also shown by showing favoritism. What you do for one resident, you have to do for them all, but you shouldn't be doing this at all, because again, you could get hurt. It is a huge liability for the owner of the company should that maintenance technician decide, well, yeah, let me go ahead and help you move this heavy piece of furniture. You have to deny that resident their request for you to help them, because you are not allowed, they are not allowed to do this. The next question or next workshop says, and we're on page 10 still, a technician is in a unit repairing a garbage disposal. The resident is in the unit. While repairing the garbage disposal, the resident asks the management technician if he can hire him as a handyman to do some other things in the unit. How should the maintenance technician respond? Well, yet again, those are things that you are not hired at that property to do, is responding or allowing a resident to hire you as a handyman to do some other things in the unit. You are there in the role of, that is your employer. You are there to fulfill that work order and move on to the next unit. That maintenance person will not be able to do that for that maintenance technician. So maybe they can send them to a website to so that they can search for a handyman in the area, but they are not to be involved with the residents to that respect, because they are there to do a specific job that they've been hired to do by the management company or the owner. A maintenance technician receives a call from the emergency maintenance service late one night. He calls the resident and recognizes the resident as a family friend who lives on the property. Now, the resident requests an emergency maintenance repair for his air conditioning unit because it's not working. The outside temperature is 72 degrees, and the emergency maintenance policy is to repair air conditioning units when the temperature is above 80 degrees. What should the maintenance technician do? Well, the maintenance technician, we said here, he receives a call that a resident he recognizes as a family friend. He does not want to go and put himself or his employer in a discrimination situation because this person is very near and dear to him. The rules of the policy and procedure at the company says that if the temperature in the unit goes above 80 degrees, then there's something we need to look at as an emergency issue. However, this temperature, it says the temperature outside is only 72. So the maintenance technician is responsible to reply to that particular resident would be to tell them to put in a work order. Again, whatever your procedure is that you have outlined as a management procedure. Is it work orders are accepted by way of the resident portal, calling the front office, stopping by and placing a work order? Whatever your procedure is, it must be adhered to and followed. You must be consistent. Remember that word consistent is relevant and pertinent to compliance. Being consistent equals compliance, understanding the rules and regulations of the Fair Housing Act. All right, everybody. So turn now, please, to page number 11, because we have taken quite an in-depth walk through, excuse me, each of the 7 federal protected classes. We've talked about those prohibited acts. We've discussed the roles of our maintenance teams. The other category under the Fair Housing Act is affirmative requirements. And those affirmative requirements I mentioned earlier speaks to reasonable accommodation and reasonable modification. So on page number 11 at the very top, when it comes to reasonable accommodation, it says, well, let me go further here where it says affirmative requirements, whether it's a reasonable accommodation or modification, allow equal access. There's that key word again, equal access to programs and facilities. So this is basically households that have a disability. We can make a reasonable accommodation, or I should say, a reasonable accommodation can be made in rules, policies, practices, or services. And it's important guidance found by in a joint statement between HUD and the Department of Justice on reasonable accommodation, several of which we will go through in this part of the training. An owner must also allow for reasonable modification. Now, modifications are those things that allow a household that is disabled as well, or a person who is disabled to enjoy the dwelling space, same as someone without a disability that doesn't have a disability. So there are times where we have to make a reasonable modification, which is a structural change. So modifications, though, are made at the resident's expense unless it's at a federally subsidized property, except for federal housing, such as HUD or rural development. Having good forms will assist in making your reasonable accommodation or reasonable modification request, but you have to know those forms are not required. Okay, so while they aid in the process, it may be a management requirement. They are not required of an individual to complete that form. And we'll talk about that as we go further in this section of the training. And you just have to be careful on that form to not ask unlawful questions. In other words, you can't delve into, well, exactly what is your disability? What's wrong with you? Questions like that. We'll look at it further. So let's look at the first affirmative requirement, reasonable accommodation. What is an accommodation? Hold on, let me make sure. Okay, sorry, I had to look at something. What is an accommodation? It is a change, exception, or adjustment to a rule, policy, practice, or service. The purpose, again, is for equal opportunity for those individuals that are disabled to use and enjoy a dwelling in public and common use spaces. We're on page number 11. When we speak of these reasonable, because we're going to break it down first, we're still talking about reasonable accommodation and what does it mean? It says a reasonable, top of page number 11 or to the middle, a reasonable accommodation can be requested during the application process or at any time during residency. However, there must be a nexus, which is a connection, okay, between the disability and the request. So to show that a requested accommodation may be necessary, there must be an identifiable relationship or a nexus between the accommodation requested and the individual's disability. Housing providers are required to cover costs that result from accommodations, as these costs are usually minimal. Additionally, a housing provider is prohibited from charging tenants fees or deposits as a result of the accommodation of their disability. Here's an example, and this is directly to, it's a generic one, but it's directly from the HUD Department of Justice joint statement. It says a housing provider cannot charge a pet deposit or pet fee specifically for tenants with a companion or assistance animal. So in other words, it is very important for you to understand, and we're not quite to the point of discussing assistance animals and companion animals. So I'm going to end up repeating this, but it's important that those of you working as a housing provider understand the difference. There's a difference between pets and assistance animals. Emotional support animals fall under the assistance animals category. Pets are different. It is okay if you have a pet policy that says there's a particular, whatever your pet policy is, you have pet fees or you have a pet deposit, you're allowed to collect those from your residents. You also have to make sure that they're adhering to the whatever occupancy rules for that particular pet. They have to adhere to those, and they must understand what those rules and regulations are that are outlined in the lease. However, if that person has a need for an assistance animal or an emotional support animal, we are not allowed to charge a pet fee or a pet deposit, because why? These are not pets, they are animals. And again, we'll talk a little bit more about a lot of the emotional support animals too that are out there. And I get it, but I'm just saying the rules and regulations say that those are not pets. In this example, let me read from the other examples on page 11. It says a housing provider, this is the second bullet point on the first gray box. A housing provider cannot charge an additional pet for a person in a wheelchair for anticipated damage by the wheelchair. An example of how we make a reasonable accommodation for a property, the housing provider that has a no pets policy, look at the last example. It says a housing provider has a no pets policy. A tenant who is deaf requests that the provider allow him to keep a dog in his unit as a reasonable accommodation. The tenant does explain that the dog is an assistance animal that would alert him to several sounds that include knocks at the door, sounding of the smoke detector, the telephone ringing, and cars coming into the driveway. The housing provider must make an exception to the no pets policy to accommodate this tenant. So you can't have a no pets policy in place, but if you have someone who is disabled, they request a reasonable accommodation, you must have a procedure in place to which you approve, you accommodate that particular request. And one thing I do want to say before we move further, I mentioned it's not new. I've mentioned it before where I told you that, policies or situations that you have at your property are not cookie cutter. Reasonable accommodations are, whether it's accommodation or modification, sometimes those are not cookie cutter, okay, depending on what that particular reasonable accommodation or request is. So you have to take every affirmative requirement that is presented to you on an individual basis and apply the rules of the law, fair housing laws, and understanding too, what are your company guidances, what are your policies, and apply it to that situation to make sure at all costs you are making that reasonable accommodation or modification. Sometimes these requests do take time. What I mean by that, I don't have a definition for what a reasonable time frame is, but I do encourage you to have a policy in place as to how long before you respond to an applicant where you're making a reasonable accommodation or modification. You do not want to take months and months, and you don't want to take weeks and weeks sometimes. You do want to reply accordingly. And I'll get a little bit more into that, into the training, but your lack of response can be a denial of the request. So your lack of response can seem as a denial of the request. So you want to have a procedure in place for replying promptly to these requests. Now let's look on page number 12, because you hear me talk about reasonable. You guys have all heard throughout, the time you've been at your property, you hear or in the industry, reasonable accommodation, reasonable modification. But what is reasonable? Top of page number 12. Reasonable accommodations must be reasonable and not cause. Here is the definition of what the Fair Housing Act says is reasonable. It must not cause an undue financial burden or result in a fundamental alteration of the housing provider's operation. If a housing provider denies a reasonable accommodation due to the request being unreasonable, then the provider should discuss with the applicant or tenant where there is an alternative accommodation that would effectively address the requester's disability-related needs without fundamental alteration to the provider's operations and without imposing an undue financial and administrative burden. What does that mean? There are times where reasonable accommodation or modification is just not going to be possible. Okay, that is the nature of it. However, and I caution you, you really must make sure you sit down, because there's no cookie cutter approach, and analyze that request. You obviously would want to get, management involved, possibly your legal counsel involved, to make sure if you have to deny a reasonable accommodation or modification, that you have exhausted all your efforts to not see another way to accommodate them. And then there sometimes that's not possible, but sometimes you may have to tell that person, well, we are unable to make this accommodation or modification because it's not reasonable, because it is going to cause a undue financial burden, or it's going to cause a fundamental alteration of our operation. But here is what we can do to accommodate you. Here's a good example. Let's look at page 12 at the example I'm going to read about reasonable accommodation. As a result of a disability, the tenant is physically unable to open the dumpster placed in the parking lot by his housing provider for trash collection. Now, the tenant requests that the housing provider send a maintenance staff person to his apartment on a daily basis to collect his trash and take it to the dumpster. Because the housing development is a small operation with limited financial resources and the maintenance staff are on site only twice per week, it may be an undue financial and administrative burden for the housing provider to grant this request for daily pickup of trash service, provide daily trash service pickup. Accordingly, the requested accommodation may not be reasonable. Remember, we have to do what is reasonable at the property. If the housing provider denies the requested accommodation is unreasonable, the housing provider should discuss with the tenant whether reasonable accommodations could be provided to meet the tenant's disability-related needs. Here's an example. For instance, how about we place an open trash collection can in a location that is readily accessible to the tenant so that the tenant can dispose of his own trash and the provider's maintenance staff can then transfer the trash to the dumpster when they're on site. Such an accommodation would not involve a fundamental alteration of the provider's operation and would involve little financial and administrative burden for the provider while accommodating the tenant's disability-related needs. So in other words, I'm not causing an undue financial burden for me as the owner, but I'm able to still accommodate the tenant's request, just not the way that they wanted it, that they requested, but it's going to serve two purposes. So it is always possible that reasonable accommodations and modifications are not approved or accepted, but you do know they are accepted. We may not be able to do that because it's not reasonable, but here's what we are able to do for you. That is perfectly fine. I do though ask that you remember there's no blanket statement, no cookie cutter approach to any case like this. You must be able to dissect that particular request and do your very best to meet it. When you're not able to meet it, you may want to run that by management, run it by legal counsel to make sure that when you do deny that request, if you haven't, that it's denied, but here's what we can do. And then sometimes there just may not be anything that you can do because the request is unreasonable. But you want to make sure that it is well documented, okay? Because that covers your butt. With regards to reasonable accommodation and denial, let's look at this at the bottom of page 12. It says, if an applicant suffering from a mental or physical illness, alcohol dependency, or past drug addiction is denied based on criminal history or bad references. So here we are looking at, past drug abuse, past alcohol abuse. They may request a reasonable accommodation to the housing provider's screening criteria, provided the following can be demonstrated. First of all, that person has to meet the definition of a disability. Alcoholics and recovering addicts are considered disabled under the Act. Recovering is the key word, not current. The relationship between the applicant's disability and their past misconduct and the steps that the applicant has taken to get rehabilitation programs completed, information about new treatment, what their support system is, and possible any medications that address the problem that has resulted as a disability because of past drug or alcohol abuse. It's a special note at the bottom of page 12. I said it, but I just want to make sure you understand current illegal narcotic users are not covered under the Fair Housing Act. The next one, if you turn to page number 12 with regards to making a reasonable accommodation and evictions, I'm going to read that gray box at the top of page 13 in a second, but I want you to look at I'm going to go to reasonable accommodation and then look at that next example. It says a person with disabilities. So this is reasonable accommodations and evictions. I want to be clear. A person with disabilities may request a reasonable accommodation as an alternative to termination of tenancy. In such cases, the tenant should be able to demonstrate the link between the tenant's disability and the action resulting in termination, and how a reasonable accommodation will permit the tenant to maintain compliance with their lease requirements. Okay, so here's an example. A tenant was very loud and disruptive in her unit due to her disability, which causes auditory hallucinations. And all of these particular examples, not the workshop, so these examples come directly from the Department of Justice as a part of that joint statement with HUD, and you can find it on the DOJ website. under fair housing. So it says a tenant was very loud and disruptive in her unit due to a disability which causes auditory hallucinations. Her housing provider issued her an eviction notice due to the disruption. Now the tenant sought treatment and began taking medication which addressed the behavior. The tenant requested a reasonable accommodation, stating that the behavior that resulted in the eviction was due to her disability, which had been mitigated by taking medication to address the issue that caused the behavior. So these are, I'm not saying they're rare because I have no proven documentation numbers to tell you how, to even back up a statement by me saying these cases are rare. But these are certain cases where, again, you cannot apply a cookie cutter approach. Some of you may never see a situation like this in your lifetime as a as a affordable housing professional. Some of you may have seen it once or twice, but this is where the rules will guide you, but you do want to make sure you understand those rules and regulations and make sure you get legal counsel so that you can make the proper decision on behalf of the management company. When we talk about protections, it's very important, in the middle of page 13, and it's on the slide here in red. It says juvenile offenders and sex offenders by virtue of that status are not persons with disabilities, that are protected by the Fair Housing Act. Okay, so not protected basically are juvenile offenders and sex offenders. Okay. When we look at a direct threat to the health or safety of others, I mentioned this early on in the training. I can't remember why, but I did talk about using your basing your decisions off of the fair housing laws and not what you feel, how you feel. Here's what we're going to look at with direct threat assessment. Page number 13, when determining whether an applicant or tenant poses a direct threat, the determination must depend on an individualized assessment that is based on reliable objective evidence. Here's an example: current conduct or recent history of overt acts. So this is, think of housing, think of going through the application process, and approving an applicant for housing and possibly having to make a reasonable accommodation. The act prohibits the denial of housing based upon fear, speculation, or stereotype about a particular disability or persons with disabilities in general. The assessment must consider the nature and duration and severity of the risk of injury, the probability that injury will actually occur, and whether there are any reasonable modifications of your rules, policies, practices, or services that will reduce or eliminate the risk of a direct threat. So here's what it speaks to. When you are basically reviewing, going through the application process and reviewing at the bottom page 13, reviewing recent history of any overt acts. So depending on what information you receive from your background checks, housing providers must take into consideration whether the applicant or tenant has received intervening treatment or medication that has eliminated the direct threat. Now, this is based on the fact you've had to go to, say, a reasonable, you've denied that person's application on one hand, and the person is asking for making a reasonable accommodation request to you based on the fact that this is no longer the case, or this is past behavior. It says, when we're talking about whether the applicant or tenant has received intervening treatment or medication that eliminated the direct threat, in such cases, the provider you have options into what you need to document, what you need to request from the applicant. Documentation from or on behalf of the applicant tenant describing how the circumstances have changed so that the applicant or tenant no longer poses a direct threat. Satisfactory assurances that the individual will not pose a direct threat through their tenancy. These, again, I know I call them a shell. Like a skeleton or a shell of a policy, but when it comes to a real situation, how do you apply it? The regulations give you guidance, but you definitely want to get some feedback from management and possibly legal counsel as to how to appropriately look at this request to make a determination. So what about My other resident safety, top of page number 11. The housing provider must have reliable, objective evidence that a person with a disability poses a direct threat before excluding him from housing on that basis. And you've got to be very, very careful, excuse me, when you are making a determination on what you feel maybe a person based off of their disability pose a direct threat. You cannot use that. You have to be objective. You have to use remember early on the earlier slide, it said an individualized assessment based on objectivity and not what is subjective, what you think, what you feel based on the information that you've gathered. Look at this example too from the DOJ and HUD joint statement on page number 14. And this is speaking to this particular example. That's what this slide is about. It says a housing provider requires all persons applying to rent an apartment to complete an application that includes information on the current place of residence, which is typically what we all look for from the applicant when we are going through the application process with them. On her application to rent an apartment, a woman notes that she currently resides in Cambridge House. Now, the manager of the apartment complex knows that Cambridge House is a group home for women receiving treatment for alcoholism. Based solely on that information and his personal belief that alcoholics are likely to cause disturbances and damage property, the manager rejects the applicant. The rejection, though, guess what, is unlawful. It's illegal because it's based on a generalized stereotype related to a disability rather than an individualized assessment of any threat to other persons or the property of others based on reliable, notice that word, objective evidence about an applicant's recent past conduct. You got to go by what's objective and not how you feel, what your fears are. The housing provider may not treat this applicant any differently than any other applicant based on his subjective perceptions of the potential problem posed by her alcoholism by requiring additional documents, imposing different lease terms, or requiring a higher security deposit, all because she's associated with Cambridge House, which is a treatment facility for alcoholism. And I do not think that's going to be an ideal resident at my property. This could pose as a threat. That is a problem. That is illegal. That is going to lead to a fair housing discrimination lawsuit. However, here's what management has the right to do. The manager could have checked the applicant's references to the exact same extent as the same manner as he would have checked on any other applicant's references. Again, treating every applicant fair and consistent, regardless of who they are, where they come from, what they look like. If such a reference check revealed objective evidence showing that this applicant has posed a direct threat to persons or property in the recent past, and the direct threat had not been eliminated, then guess what? Then the manager could have reject the applicant based on the direct threat. Again, these can be very rare situations that are encountered, but they nonetheless can, it's a part of life, and they absolutely can come your way one day. So I want to make sure that you understand what the rules are. But again, you know, they sometimes are not decisions you can just make on your own. You want to absolutely discuss with management, and you may have to get legal counsel involved as well. All right, good people. Do we have any workshops? Oh, no workshops, but we can talk now about companion assistance animals. And this is always one of those interesting parts of the training. We're not going to spend, we still have quite a few topics to cover, but just spend a little bit of time on it. I want to give you a number. I'm going to give you two numbers. I'll give you a percentage, I should say. And it's a very important percentage as we start talking about companion assistance animals. The percentage is 60%. That's a huge number. When you think of 100%, 60% is over half of 100%, right? 60% of all fair housing complaints relate to the denial of reasonable accommodation, and those complaints regarding the denial of an assistance animal are one of the most common types of fair housing complaints. I told you earlier that, a lot of people, everybody's not bad. A lot of people do not set out to commit a fair housing violation. Unfortunately, however, that is exactly a lot of times what ends up happening just out of lack of knowledge of the law. So 60% is a huge number of all fair housing complaints with regards to those that are not knowledgeable about the fair housing rules and regulations. With regards on page 14 of companion and assistance animals, remember, it's very important to distinguish between pets or assistance animals. Those companion emotional support animals are not pets. Those animals are for that disabled person or persons to provide a service to assist them, whereas pets are different. When we talk about emotional support or assistance animals providing assistance and emotional support, the person must have a disability and be able to show the need for the disability. But yet I'm going to talk to you about what we can ask and what we cannot ask. It is legal if the nexus, okay, so the request for the disability does not, or the disability and the request are not obvious, then we are allowed to ask, is the person disabled based on the definition of disability under the Fair Housing Act? And is that animal needed for that disability? We cannot ask the nature, though, of the disability. And we'll get into talking, well, we're here now, so we're going to talk a lot, talk a little bit more about assistance animals. So at the very bottom of page number 14, it says assistance animals are often referred to as assistive animals, support animals, therapy animals, companion animals. They are all the same with regards to that category, companion assistance animals. It says assistance animals can perform many disability related functions, and I'm on page 14 at the bottom, such as guiding individuals who are blind or have low vision, alerting individuals who are deaf or hard of hearing the sounds, providing protection or rescue assistance, pulling a wheelchair, fetching items, alerting persons to impending seizures, providing emotional support to persons with disabilities who have a disability-related need for such support. When we also talk about the, I'm going to get to a reasonable notice coming up here soon, top of page 15, it says the request must be approved, and we put that in bold font for you, if they demonstrate, one, that the person seeking to use and live with the animal has a disability, and then two, is a disability needed for the assistance animal. Again, this is when the disability, the nexus is not clear. The disability and the request is not clear. As a housing provider, we are allowed to ask the person that needs the reasonable accommodation those two questions, but you cannot, I've said it before and I'll say it again and probably say it again, you cannot ask about the nature of the disability. Okay, that's like saying, so, okay, you have a disability, but what is it? What's wrong with you? You look fine to me. Can't do that. The request may be denied if the specific assistance animal in question poses a direct threat to the health or safety of others that cannot be reduced or eliminated by another reasonable accommodation, or the specific assistance animal in question will cause substantial physical damage to the property of others. I often have someone, I often have people ask me in the training, well, what about pit bulls? Well, here's what I say about pit bulls. On page 15, right above the gray box, direct regulations say, direct from the regulations it says, I'll rephrase that, you cannot impose weight, size, or breed restrictions to companion or assistance animals. So I'm going to delve more into it, so hang in there with me. But whenever we're dealing with federal rules and regulations, they state what it is. They state the rules, this is it. However, there's sometimes it's a blanket statement, but then you've got to pull back the layers and kind of decipher, okay, this is the rule and regulations, but this is a problem for me. How am I going to apply this at my property? Because we don't allow aggressive breeds such as pit bulls. But the regulations are telling me that I cannot impose any restrictions, weight, or breed sizes to companion and assistance animals. So I recognize companion and assistance animals are not pets, or yeah, they're not pets. They're for that disabled person to perform a service. Here is specifically from a HUD memo on the gray box 6-1-2006. It says, gave guidance to housing providers for those particular breed of animals that may be considered aggressive and how are we, is our responsibility to allow reasonable accommodation as a companion or assistance animals. It says if a housing provider's insurance carrier would cancel, substantially increase the cost of the insurance policy, or adversely change the policy terms because of the presence of a certain breed of dog or certain animal, HUD will find that this imposes, excuse me, everyone, imposes an undue financial and administrative burden on the housing provider. Going back to, remember how I broke down to you what is reasonable? Is it reasonable? However, the investigator, so in other words, if the housing provider's insurance policy would cancel, if it's, it's a higher insurance based on the liability of these particular type of animals, it could be a problem for that owner obtaining insurance at the property. So those particular breeds are not allowed, but yet another regulation tells me for fair housing, I have to allow them to be companion assistance animals. So you have to still take in that request if that person's assistance animal is a pit bull, and you have to determine, is it going to be reasonable? Is it going to cause an undue financial or administrative burden? However, the investigator must substantiate the housing provider's claim regarding the potential loss or adverse changes to the insurance policy. So that housing provider is saying, this is going to cause me an undue financial burden or administrative change. I don't know how I'm going to be able to allow a pet bull at the property. And this particular memo was focusing on a provider's insurance carrier. It says, let me start over. The investigator must substantiate the housing provider's claim regarding the potential loss or adverse change to the insurance policy or insurance coverage by verifying such a claim with the insurance company directly and considering whether comparable insurance without the restriction is available. So is it possible then for you to obtain insurance with another carrier to cover this breed of pit, or the pit bull breed, so that you can accommodate the person that is requesting a reasonable accommodation for that particular assistance animal? It may not be possible, okay? However, if you notice that gray box speaks to doing your due diligence, you've got to look at all avenues before you deny a reasonable request. You're trying, you want to do what you can, you want to help them. You just might not be able to. And so you have to make sure that you're going to be able to demonstrate that. Should it even come up as a question with HUD, why we weren't able to do it. So again, I lean heavily to your legal teams to help guide you with certain decisions like this. Let's look at the fair housing notice that I have on the slide, as well as what's on page number 15. Now, this was a notice that was issued in January 28th of 2020. And this provided to housing providers some clarification with regards to the documentation required for companion assistance animals. It says, according to the HUD Office of Fair Housing Equal Opportunity, the notice explains certain obligations of housing providers under the Fair Housing Act with respect to animals that individuals with disabilities may request as a reasonable accommodation. Now, this notice came out of an overabundance of concerns. Overabundance is not the right word. That's not what I meant to say. Out of an abundance of concern from housing providers to HUD with regards to companion animals or emotional support animals, excuse me, because as those of you that are in the industry know, it's unfortunate where the good people get rolled into the ball of people, of those that do not make the best decisions. And, there's always, for every rule out there, there's always somebody trying to tweak the rule to make it work for them and how they want it to work. And I know, quite frankly, you all have probably concerns or have been facing issues where you feel this is not an emotional support animal, but that's what they're telling you. And your hands get tied. And yes, your hands still to a degree can be tied, because you have to understand the rules of the Fair Housing Act and how to apply them. So out of these, the abundance of concern from housing providers, HUD made a clarification, and I encourage you to please write this down, because this is actually a very good update to companion assistance animals. It didn't change the rules and regulations for what is considered a companion or assistance animal. But what it did do was give some clarification as to the documentation that what owners are required to have versus what they don't have to accept, because we know that these emotional support animal requests, people can go online to a particular company and get that doctoral verification that is necessary. But yeah, let me read it to you. Let me do a little bit. I'm going to read this to you and then I'm going to sum it up. So the notice had several key points. It said is assessing a person's request to have an animal as a rental, a reasonable accommodation under the Fair Housing Act. It also addressed that a resident may request a reasonable accommodation either before or after acquiring the assistance animal. So again, not changing the original rules, it just made some clarifications. Documentation from the internet, criteria for assessing whether to grant the reasonable accommodation, and documenting an individual's need for assistance animals in housing. So the bottom line is, in this letter as you read, and it comes with a nice question and answer document too that is attached to it, HUD made it very clear for to housing providers that going online, so residents that go online for documentation of service animals is irrelevant. So we have companies that are out there that are online that unfortunately take advantage of those that are disabled, and sometimes those that just, well, anyway, looking to tweak the rules, can go to these particular sites and get a document that says my pet is certified and my pet is registered. Bottom line is, and HUD said in this particular letter, that HUD considers these websites as taking advantage of people, and it is a waste of money. That is flat out stated in that particular letter. Here's the only concern that landlords, owners have to be concerned with regards to making a reasonable accommodation for an emotional support animal or an assistance animal. Does the person meet the definition of a disability? And is the animal necessary to assist with the disability? You know, what is it trained to do? Because that's what an assistance animal is, you know, trained to perform a certain task or emotional support. That what is it needed for that person with a disability for emotional support, period. Those are the only two questions we need, answer when the nexus is not obvious. The question has come up too, where you will have one household have multiple requests or have multiple emotional support animals, as they're telling you, one for one disability and one animal for another disability. We need to get it documented. You need to get it by way of a medical provider that will state that it is necessary, that the definition of disabled, so that person has to meet the definition of disabled, and is that person needed for the person with the disability, okay? So again, and it's interesting because I understand as a housing provider who, you know, you get these federal rules and regulations. Well, the regulations say this, but I still have to apply it. And what I mean by that is, while HUD made it very clear that these websites, the owners do not have to accept these letters from these particular websites, sometimes maybe it is a legitimate doctor that is able to verify the need, and it's online, okay? I don't know that particular, I can't give you any one particular situation, but it kind of gave a little bit of backup to housing providers that they do not have to accept these letters. You can have your own form asking your own questions that you, by way of third party, reach out and you get that documentation from the medical professional, medical provider, period. Okay. So I encourage you to go write down this notice information, Google it, print it up, read it. It's pretty easy read. You know, some of the regulations are blah, 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 but this one's not. And it's got a great question and answer section for you as well. Okay. Let's go and look at applying multiple laws where we have the Fair Housing Act, and we have to look at ADA, because the assistance animals, well, I should say those service animals, are trained animals that perform certain functions Those are allowed everywhere under the ADA regulation guidance, but under the Fair Housing Law, we are at the bottom of page number 15, Fair Housing Laws, it says what's covered by fair housing and Section 504 are those particular companion animals that are confined to a unit. So fair housing laws cover those companion animals confined to a unit, but then the ADA, those service animals, are allowed everywhere. So when applying both ADA and fair housing, Section 504 rules for assistance and service animals, you do not use the ADA rules as justification for reducing whatever your requirements are for fair housing. You have to understand how both laws apply, and they are right here. Applying fair housing under Section 504 to your residents, that is allowed inside of the units, but ADA applies to not only your applicants and your guests, not only your residents, but your applicants and your guests, and they are allowed in common areas. Under the ADA, you can only ask, is the dog required because of a disability? If so, what work or task has the dog been performed to train? Let's look at some workshops. It's always fun when we get to look at some of these workshops. So let's look at on page number 16, please. Very first one. It says Claire is applying at Crescent Bay Apartments. Now she is disabled and requires the use of a motorized scooter to get around. The leasing agent tells Claire that she will not be able to rent to her because the property recently upgraded the flooring in each unit, and her motorized scooter will cause damage to the new floors, and suggests she apply at a community down the street as it will be a better fit for her. Is the leasing agent correct? I certainly hope we all agree that unfortunately Claire is incorrect, okay? This individual that is disabled and requires the use of a motorized scooter is allowed to apply at the community as long as she meets the qualifications of the program, any occupancy requirements that you may have. She is allowed to live there regardless of the fact that the floors were recently upgraded, which is nice. It's a great feature to have in the units, but her motorized scooter is what she needs to get around because she is disabled. So you have to, by Claire steering her, Claire discriminated against her because she was in a scooter. She also steered her down the street to tell her where she felt it would be best, because basically she was saying, we don't want any damage to our units. We just got these beautiful hardwood floors. Your motorized scooter is going to shred them. So why don't you go ahead and go down the street? No, Claire's made all kinds of boo-boos, and that is going to cause a problem for the owner. We cannot discriminate against those individuals that are disabled. We cannot choose housing on behalf of someone. It is we have to leave. It's their choice in housing. That's what fair housing is about, equal opportunity. Victor, next one, is a resident at Whispering Woods Apartments. Now he is recently disabled and confined to a wheelchair. He now requires a service animal to assist him with several of life's daily activities. Management advises him that based on the community pet policy, he will be charged a pet deposit and rent. Ouch. Is the management correct? Absolutely not. Victor is disabled, confined to a wheelchair, and he requires a service animal. It is important for you to remember, service animals are not pets. We cannot hold those individuals that have a service animal to the same rules as those individuals with a pet. And we have pet rules, pet policies, such as a deposit or charging pet rent. Okay, we are not allowed to do that for companion or assistance animals, period. It is a fair housing violation. All of these violations, both of these, could end up costing the owner a lot of money. So we count on you. Thank you for being on the training, because we count on you to know the rules and regulations and how to apply them. Let's look at hoarding. Okay, hoarding is another one that, it falls under it's a disability according to the Fair Housing Act. It says, how should housing providers ignore the many potential hazards from, or not how should housing providers ignore the many potential hazards from hoarding? No, we can't ignore it. It is very important. It is a real thing. It can be very serious, and we have to look out for our residents, and we have to keep the property decent, safe, and sanitary. But yet, guess what? We have to abide by the rules of fair housing and recognize that hoarding is a mental disability. Since 2013, the American Psychiatric Association has recognized that hoarding is now considered a mental disability and is therefore protected under the Fair Housing Act and the Americans with Disabilities Act. So that's the ADA. This means that the person who suffers from hoarding must be considered eligible under the Fair Housing Law to reasonable accommodation. Here's some important numbers to know about hoarding from the APA. Hoarding disorder occurs in an estimated 2 to 6% of the population. Some research shows that hoarding is more common in males than females, and it's more common among older adults. 3 times as many adults 55 to 94 years of age are affected by hoarding disorder compared to adults 34 to 44 years old. When we talk about hoarding, it's important for you to understand, first of all, what is hoarding? We may see it if we do not have this mental disability and we suffer from hoarding, we may think that this is just trash, is junk, or it's just a hot mess. But persons that have a mental disability of hoarding, it's so much more than that. People with hoarding disorder excessively save items that others may view as worthless. So again, we see them as trash, we see them as junk, or a mess, a hot mess. They have persistent difficulty getting rid of or parting with possessions, leading to clutter that disrupts their ability to use their living or workspaces. Hoarding is not the same as collecting. People with hoarding disorder often save random items and store them haphazardly. So as a housing provider, what am I supposed to do? I run this fine line with, I have a resident who I suspect is a hoarder. They are not, or based on the fact, let's say we've gone into their unit and it's just unlivable. We can't even make our way through the foyer to get to the kitchen. It's a hazard. What is, as a management provider, what am I supposed to do? I can't ask this person, what's wrong with you? Why are you doing this? What kind of, something wrong with you up here? We can't do that. We may want to do it, but we really can't. So what does the housing provider do? Well, you are responsible. Remember, you may not have that job title of being an asset manager, but you are responsible for asset management. So you have to make sure you stay alert for signs of a hoarding problem. This a lot of times can be noticed if you have frequent property inspections or unit inspections. I mean, when you were working at whether it's the LIHTC program through Section 42 or HUD or rural development or home funds, it's always something going on at the property. It's always an inspection. We always have somebody out doing something, but you're always, it's always dress rehearsal for the actual audit itself. So, you're responsible for making sure that you're keeping the property decent, safe, and sanitary. So unit inspections could be one way. The other one could be through your maintenance teams. Your maintenance teams are constantly going in and out of units too. Make sure they understand what hoarding is and things to be on the lookout for to alert you. Once an incident is discovered, you can't ignore it. You have to be proactive with it. You have to be proactive in seeking to assist the resident in resolving the issue. Housing providers of multifamily properties must develop procedures on how they deal with potential hoarding issues. They must make every effort to provide a reasonable accommodation before termination of tenancy. Okay, so you discover an issue of potential hoarding, and you're like, this is just gross. This is disgusting. This is a problem not only for this unit, but it's a problem for the whole building because it could end up causing rodents and vermin, and it's just a mess. They got to go. I'm going to give them a 30-day notice to vacate. Absolutely do not do that. You want to have a process. First of all, you want to retain these residents. We just need them to get the unit because in order because we are responsible for keeping the property decent, safe, and sanitary. So on one hand, you have an obligation to that decent, safe, and sanitary requirement for federally funded housing, as well as the LIHTC program. On the other hand, I am dealing with a person that has a mental disability, and I have to be very careful to abide by the fair housing law. So this is what you're going to do. Now, well, let me go back to the slide, sorry. When you're dealing with the situation of hoarding and you have to go and assess the unit, you want to make sure that you go to the apartment and remove any judgment. So remove your manager hat, and you're going to start documenting the condition, of course, of the unit, because you know the fact is it's probably going to be a disaster. And what you want to make sure that you have is you document the condition of the hoarder's home. You have to get legal counsel involved, or management, whatever your procedure would be. But you know, you don't want to rush to judgment, don't want to rush to giving them a notice to vacate, because you want to make sure you have a process outlined to cure the issue. You want to give the resident every opportunity to rectify the situation. That's where that interactive dialogue language will come in. You want to have an interactive dialogue from the time you noticed the problem to the time you addressed it with the resident, to saying, okay, we're going to give you, I'm making this up, whatever a policy would be. We're going to give you 5 business days to get this cleaned up. I'm going to come back and check the unit. Let's say you go back and check the unit, and the person might have think that they made it better, but they didn't. Or the person never saw a problem with it from the beginning, and they think you're crazy and why are you bothering them, and they didn't do anything about it. But it's your responsibility to follow up and notate at the end of the cure period, they did not abide by what our agreement was. In addition to that, now you are going to have to find out from management side, what will my next step be? Because a lot of times hoarders are very resistant to help because they don't see the problem. I don't have the problem. You have the problem with my stuff, right? And the fact of it is we do, because I have to make sure I keep the property decent, safe, and sanitary, and the unit is in disrepair and it's not abiding by any of those regulations. So it definitely may escalate to the point where management and legal counsel has to get involved to guide you as to what your next step will be. But my biggest takeaway is for you to understand, you want to be able to demonstrate to all the powers that be, here was my interactive dialogue from the time the situation, I was alerted of it. We talked to the resident, we gave a cure period. It was something else. I hate when I lose my train of thought, but it was something else I wanted to have as a bullet point before you discuss it with legal counsel, because you know, maybe sometimes there's family that can assist to help. Okay, sometimes there's no family. All right, and you know, what does your legal team say about what the next step would be before you immediately move to termination of tenancy? So just know that hoarding is covered as a disability, mental disability, under the Fair Housing Act. Here's a workshop. Turn to page number 17 at the top. A maintenance worker receives a work request to repair a leaky faucet. Upon entering the unit, she has a difficult time opening the door. Once she's in the unit, she discovers boxes, papers, and a number of other items blocking the front door, as well as other areas of the unit, making the unit unsafe to access and walk through. Maintenance notifies management, and the resident is given a 7-day notice to clean up the unit, but unfortunately does not do so. As a result, management begins the eviction process. Should the manager have taken a different approach based on the guidance I gave you before this slide? Absolutely. You do not want to immediately go to give them a notice to vacate. We want to retain that resident. We have to recognize this is a mental disability and do all that we can to work with them before those exhaustive efforts have led to, we've got to evict you. Yet, I will go ahead and say, I get it. You have to keep the property decent, safe, and sanitary. So that's where the interactive dialogue is helpful. It's your documentation to show what led up to the eviction if it comes to that. All right. Let's look at marijuana on page number 7. We'll look at it. We're not smoking it. On page 17, reasonable accommodation marijuana. Should housing providers permit the use of marijuana? Although, and I'm going to read it, and then it's going to be real easy for federally funded properties, because it's a one answer, which is no. Although marijuana remains prohibited by federal law, an increasing number of states have legalized the drug for medical and recreational use in the past few years. So bottom line is, should housing providers permit the use of marijuana? Here's what the private market says. We'll start with that one first. If it is legal in a state, it may be made as a reasonable accommodation. This is in the private sector. If legal in a state and the owner prefers not to permit the use of marijuana, they can refuse the request for reasonable accommodation. Why? Because they can stand behind the fact that it is federal law. Marijuana is still a Schedule I drug, which means it is federally illegal, although some states are recognizing it for recreational and medicinal purposes. Under the private sector, a non-smoking building can prohibit smoking anything. If not legal in the state, it will always be illegal on the premises. That's in the private market. Private market is given a little bit of leeway. Keep it in mind, though, it is not a federal, it's still illegal. It's a Schedule I drug. Federally funded properties, guess what? It's not permitted, period, either for recreational use or medicinal use. Regardless of the local law, the state law, it is federally not approved. It's a Schedule I drug, and therefore it is not allowed on federally funded properties. And this is also a very, it's a hot point for individuals that find themselves, unfortunately, that legitimately, we'll say they have their medical marijuana card. And by the way, at federally funded properties, just because someone may have their medical marijuana card doesn't mean that you are allowed to allow them to smoke marijuana at the property, because it is a federally funded property and it is also Schedule I drug, which is illegal federally, even if the state says okay. And so there are a lot of individuals that do need the use, have a medical marijuana card for the use of, say, to assist them with chronic pain. It is a really unfortunate or hard situation, because there is a lot of back and forth between state and federal government. I do know that certain Congress people, I can't name any of them right now, but Congress people are bringing it to the forefront with providing housing, because listen at how the rule can affect housing. On one hand, the rule does say it is a Schedule I drug. Federally, it's not allowed, but some states are allowing it to be legal based on medicinal or even recreational use. Yet, the purpose of these federally funded subsidized housing is to provide housing. That's what we're doing. But and there have been many cases, there's so many cases out there where an individual has said, well, I have my they're living at a federally subsidized property, federally funded property, and they say, well, I have my medical marijuana card, I have chronic back pain, I need this in order to help me pain manage. Landlords have been at the mercy of the law with receiving that federally funded money to provide housing. And they've had to tell individuals, I'm sorry, but you have to make a choice, because you can't live here and have your medical marijuana card and smoke marijuana, even if it is for medicinal use, because it is a Schedule I drug and it's federally not accepted. So you make a choice either between marijuana or housing. And that can be a hard one for some people. They're in chronic pain. Now, I can only imagine, when I get a headache, I know how that feels. And when it lasts longer than an hour, I'm climbing the walls. So you've got people that are dealing with serious issues. And then you also, now though, owners, landlords are at the mercy of the law and they can't allow it. So that can also, so it's kind of counterintuitive. You've got one regulation that is causing causing an adverse action for something else, because now the person does have to choose between pain management and housing. Okay, and a lot of times there are several cases where landlords have actually evicted residents because they were smoking marijuana, and they know that that's not following the rules of the program to which they're receiving money for to have that property, and they have had to evict them, and that is legal. It is legal. So, kind of stay tuned for it, because, Congress, mission was all, the mission of, I should say, was to provide drug-free federal assistance housing, but it is really still one of those things that is still going back and forth between state and federal government, and how are they going to meet somewhere in the middle. Stay tuned. Stay tuned. All right, everybody. Oh, wow, look at that. We're about 10 minutes away from our next and will be last break of the day, and then we'll be rounding out this training. So let's go ahead and keep pushing forward, and then we'll take a break in about 10 minutes. All right, so we've already discussed reasonable accommodation. Now we're going to look at reasonable modification. So that's the second affirmative requirement under the Fair Housing Act. Now, the definition of modification speaks to a structural change in order to afford the full enjoyment of the premises. This is still speaking to making sure that those that have a disability have equal access. It can include interior and exterior dwellings, as well as common and public areas. Okay, so there are times where we may have to make a reasonable accommodation, such as installing grab bars in bathrooms, roll-in showers, or installing a ramp for an individual with mobility impairment. And this too is why it's important for your maintenance teams to know the fair housing laws, because guess what? For a reasonable modification, we require or count on them to make these modifications in the units to accommodate individuals with the disability. And it's always nice, it's not just one thing to know this is what I'm supposed to do, but it's always nice to know this is why I have to do what I have to do. It is important to regulations. So as with reasonable accommodation, there must be a nexus, which is the connection or a relationship to the applicant or tenant's disability and the modification that they are requesting. Who pays for these modifications? Well, if it is federally subsidized housing, okay, such as rural development, or federally funded housing, such as rural development or HUD, they take care of those particular accommodations. Otherwise, the tenant would take care of those accommodations. Okay, so the tenant will be responsible for any upkeep and maintenance of the modification that's used only by the tenant. With regards to making the request, I want you to know that the request, hold on, sorry, turn to page 19. Making the request. Now, the request can be made at any time, either during the application process or during the residency or tenancy. It can be made orally or in writing. It can be made by a family member or a person or someone else acting on his or her behalf, such as a caseworker or advocate. And the request does not have to include the actual words accommodation or modification. So we're going to talk about, I'll go ahead and talk about it now, but it's going to be kind of repetitive because I'm going to talk about the form. It's a good idea for a housing provider to have a form, but the Fair Housing Act specifically says when making a reasonable accommodation or modification, you don't have to have them complete a form. But if you have a form in place at your property and you present it to the resident and they fill it out, or that's making the reasonable accommodation, they fill it out with no problem, then that's okay. But what if they refuse? Can you make them? Can you deny their request because they refuse? Absolutely not. What is your procedure then if they don't complete the form? Is it something that you complete based on the information they've given you? Document why you completed it, file away. It's just due diligence. It's covering your butt. So again, it's okay if you have a form, but note that the person making the reasonable accommodation or modification request does not have to complete that form. Here's another exercise. Page number 19. Ms. Cross lives in Falcons Reserve. She makes an oral request that she be assigned a mailbox in a location that she can easily access because of a physical disability that limits her ability to reach and bend. The manager would prefer that the tenant make the accommodation request on a pre-printed form, but the tenant fails to complete the form. The manager informs Mrs. Krause that she cannot accept her reasonable accommodation request unless it's in writing. Is the manager correct? No. Remember, we can have a form that we would like for them to complete for our files, but they don't have to complete it. It is not a contingency upon you complete this and I'll look at your request, or you complete this and I'll grant your request. You know, we have a procedure. Would you complete this form? They say no, okay, you're moving on. You still need to document it in your file, look at the request or consider the request, approve it, deny it based on reasonable accommodation, what's reasonable, and move on. Okay, so you do have to, again, dissect that particular request and decide, is it reasonable? But you do not have to make that, you cannot turn that person away because they don't want to complete your form. So with regards to requests, we have forms. Do I need to know anything else? And we're on page number 19. It says a housing provider is permitted to obtain information that is needed to evaluate if the requested accommodation is necessary due to the applicant's or tenant's disability. Again, if there's a connection or a nexus between the request and the disability, and you don't need to do anything. A housing provider may not request any additional information if the tenant's disability is obvious or otherwise known, and the need for the requested accommodation is readily apparent. So again, we don't need a form if the nexus is obvious, connection versus the disability. However, in response to a request for a reasonable accommodation, a housing provider may request reliable disability-related information that says, one, is necessary to verify that the person does meet, this is when it's not, the nexus isn't obvious. Does the person meet the definition of a disability? Describe the needed accommodation and show the nexus between the person's disability and the need for the requested accommodation. Okay, that's when it's not obvious, because not all disabilities are visual. You can't always see them, and you can't ask them what's wrong with them. You're not allowed to do that. So that's why, again, forms do aid in compliance. They aid you with getting the information you need. They aid you with consistency and documentation. It covers your butt. At the very bottom of page number 19, it says a housing provider may request documentation that the tenant or applicant meets the Fair Housing Act definition of disability. And here's how it can be verified: by the individual themselves, or you could actually accept, if your management practices accept a letter from Social Security Disability, you can do that as well. From a doctor or other medical professional, from a peer support group, non-medical service agencies such as home health care service, or what's the other one? Caregiver services, a reliable third party who is in a position to know about the individual's disability. But here's what I want you to look at on page number 20 about what cannot be asked, what you should avoid asking. Do you have a disability? Do you associate with anyone who has a disability? What's the nature or severity of your disability? Remember, I just bottom lined it for you and say, hey, look, what's wrong with you? I can't see it. I can't tell what's wrong. We're not allowed to do that. Do they meet the definition of, you start with the basis is, do they meet the definition of the Fair Housing Act of what is disabled? And you go from there. You may ask questions, and again, we're on page number 20. You may ask questions as long as these questions are asked of who? All. That three-letter word speaks of inclusiveness. All applicants, including those with and without a disability. A housing provider is permitted to obtain information that is needed to evaluate if the requested accommodation is necessary due to the applicant or tenant's disability. Okay, so the housing provider has to make a determination when it's not obvious, when that nexus is not there. I tell you what I'm going to do. we are almost finished with this particular slide, but I'm going to stop right here because it'll take us past our break time. And I think we all deserve this break. So I'm not going to drag it out. It is right at 3 o'clock Eastern Standard Time. Let's take a 10-minute break. And when we come back, we'll be finishing up. All right. So everybody take a 10-minute break and I'll see you at 3:10. Okay.